for the record, as I indicated at the time of plea, we do have a joint recommendation in this matter for sentencing, and that recommendation is for community control sanctions. The state has reserved the right to argue for whatever sanctions or terms of that community control may be appropriate during our sentencing argument here today. I would state for the record, Your Honor, that the defendant does have, as of today, 102 days of jail time credit. Thank you.
And just for the record, prior to agreeing to the joint recommendation of community control sentences, the defendant is also.
Yes.
All right, Ms. Brown O'Neill.
Thank you, Your Honor. On behalf of the defendant, I have had an opportunity to review the pre-sentencing investigation report. I have reviewed it in its entirety, and at this time, I do not believe that I have any additions, corrections, or deletions, and we are prepared to move forward with sentencing. I would note that I did prepare a sentencing memorandum that will be incorporated in my arguments. Thank you.
Thank you. And I did, in fact, read your sentencing memorandum, as well as all the attachments, and a lot of it in impact statements as well. So, Ms. Brown O'Neill, would you like to argue on behalf of your client tonight?
Thank you, Your Honor. On behalf of Ms. Montgomery, aka Ms. Bostic, in reference to litigation, Your Honor, as I indicated, I did want to incorporate my arguments that were made in my sentencing memorandum. And in addition, I would first like to note that Mrs. Montgomery's daughter is present in the courtroom and would like to address the court at the appropriate time. I will defer to the court when I think that is appropriate. I will say, Your Honor, as is reflected in the numerous character references that were attached to the sentencing memorandum, it is evident that the conduct that has brought my client here today is not indicative of her character in any capacity. Mrs. Montgomery had been newly married into the family that had a significant back and forth with their young adult and teenage stepchildren for Mrs. Montgomery, and the other side in some back and forth feud that resulted in the actions that brought us here today. I do not have to note to this court that my client was not in any way involved in that whatsoever. What brings her here is her conduct after that. I will say that understanding that Ms. Montgomery's conduct meets the prima facie elements for the charges, which is why she pled, this turns on a question of intent. What I can indicate is that Mrs. Montgomery was under the knowledge that there had been a significant amount of threats back and forth between the parties, and there was this constant feuding and threats against her family. In an effort to protect the smaller children in her family, she moved her family out of Paynesville to several local hotels, attempting to try to avoid any more issues and retaliation as relates to this ongoing feud. Her conduct was wrong. She understands that. I have had significant opportunities to discuss this with her and understanding what she did. I can truly say that in the moment of the knowledge that she had, what she believed had occurred, what was being told to her, because she was not present at the initial incident. So a lot of what is going to be put at the state of Ohio operates under the premise that Ms. Montgomery was a knowing participant. But at the time of her in the heat of the moment actions, she had misleading information and not all of the full information. So she acted out of protection. It is not given to this court as an excuse, but to give an understanding of why she made the choices that she made. I anticipate that my client is going to address the court, and she will further expound upon these arguments that I'm making, that it was not her intention to elude the police and to mislead them or to in any way get in the middle of the investigation and the police doing what was necessary. Mrs. Montgomery thought that she was moving the car in an effort to, one, move the car out of this residence. There was this continued shooting. She was concerned. She did not know the full facts of what had transpired. Same thing with the hotel, as I already indicated. As it relates to Ms. Montgomery as a person, this court is aware that my client has no criminal history whatsoever. Prior to coming into this court, she had just gotten married and moved to the Paynesville area. She is not a native of this area. So whatever history exists, she was unaware of because she is not from this area. She entered into a marriage, moved into this area from that marriage. She was at the Arby's in Euclid, Ohio. She has 4 children and 7 grandchildren. As I indicated, she has no criminal history. So ultimately, Your Honor, this state of Ohio and defense have entered into a joint recommendation for community control. It is evident, the court is aware, that we do not agree as it relates to what the terms of that community control should be. The state of Ohio was going to argue for the maximum local incarceration of 180 days. My client has already done 102 days. Her bond was set at a number that was impossible for her even to attempt to try to make. What is my viewing the purposes and principles of sentencing as outlined under the revised code? I believe my client is amenable to a community control sanction. If you look at her family support, her criminal history, the purpose of her conduct and intent, the fact that in looking at the protection to the public, my client's conduct did not directly harm the public in any capacity. I argue that wholly understanding that the state of Ohio's argument is that if in her actions, the Painesville Police Department would have been able to do their job essentially faster. Your Honor, this court is aware that I disagree with that point. From my understanding upon information and belief, the other co-defendant, my client's wife, was attempting to reach out to the Painesville Police Department on behalf of her children. Those are not my client's children. And again, she only knows a portion of the information related to this murder, why it happened, what is going forward, because of her new involvement with the family. Again, it's not an excuse, but it is to offer an explanation. Ultimately, Your Honor, we are asking this court for community control sanction for multiple reasons. One, I believe her conduct makes her amenable to a community control sanction. Her conduct as it relates to her time and incarceration and her life prior to this incident. This one isolated incident has had such a significant impact on her life. She's been in jail for 102 days. She cannot return to the city of Painesville because she has nowhere to live here. She has lost her home. She is not from here and quite frankly does not intend to return here because of everything that has surrounded this entire incident. If you go to the community page, you see all of the comments, the threatening, just the things in the back and forth. My client has no desire to be a part of that. Additionally, she has 4 children. They're adult children, but she raised them on her own. Those children rely heavily on her mother. She has lost her income. She has nothing. She has to start from scratch. Going to prison on her first initial crime, which has no presumption for prison, would detrimentally affect her life. It would affect her children's lives. It's going to affect her grandchildren's lives. That is not to say that the victim and the victim's family lives have not been detrimentally affected and that this has not been a situation that has hurt them and caused them great pain. I in no way am trying to minimize that, but we are here to review the conduct of Mrs. Montgomery and the conduct of Mrs. Montgomery alone. Mrs. Montgomery did not commit a murder, and if she had known the full facts, I am confident that she would have made different decisions on that day. We are all playing Monday morning quarterback as it relates to what was going on in her mind. This was a heightened situation. She had just been told that her stepson had been shot. She did not know why. She did not know the factors around it. So we submit to this court that she is amenable to community control. I would ask that the court allow my client to speak as well as her daughter on her behalf. Thank you.
All right, thank you. I'd like to start with her daughter on her behalf. We do not have her court reporter. She's out ill today, so everything's being recorded electronically. So when you can stand up, you don't have to come up here or anything. Just stand up where you are. And before you address the court, please just tell us your name.
Hi, my name is Jasmine.
Sorry, Jay, what's your last name? Jay?
Montgomery.
Okay, thank you.
I would like to say that my mom spent the last 30 years working her entire life by herself to do everything she possibly can for myself and my siblings. She's raised us morally correct. She's taught us empathy. She's taught us to always take accountability for anything we've done.
Thompson.
Yes.
Before you are sentenced, you have an opportunity to address the court. What would you like to tell them?
If I may, I would like to offer my condolences to the family. I'm very, very sorry for your loss, especially to the mother. The mother must have felt that pain. And, Your Honor, I'm not a bad person. I just want everybody to be safe. I didn't even know I was breaking any laws. I was just scared for my life, the children's life, mother's life. I just wanted everybody to be okay. I did ask them, family to forgive me. I made a mistake, and I took the consequences.
Anyone else? Anything else, Ms. Brownlee?
Nothing further, Your Honor, thank you.
Ms. Blake, on behalf of the state of Ohio.
Thank you, Your Honor. I do have some comments that I'd like to share with the court today, but I do want to make the court aware that Will Sheffey's family is here today in the back of the courtroom, Your Honor. And I know his mom, Tiffany Phillips, and his sister, Bethany Phillips, would like to address the court, and if the court is so inclined, I would defer to them first and reserve comment until they've had their opportunity to speak here today.
That makes sense. So who's first?
Yeah.
Same thing, you can stay where you're at, just make sure you say your first and last name before, so we have a clear record, please.
My name is Bethany Phillips, and I'm should at 6:30 to make sure I was up for work and to let me know how much he loved me. His smile was genuine, and he warmed everybody's heart he interacted with. Wyllyam was very family-oriented and consistently showed up for the people he loved. Even when others tried to attack his character, he kept a smile on his face and carried himself with dignity and strength. That's why it's painful to believe that his life was taken so violently. This entire situation had caused my emotional and mental health to decline. I've had to be placed on medication to control my anxiety and insomnia. My days are forever filled with tears and painful, heavy heart, to where most of the time I can't breathe. I struggle with feelings of helplessness, anger, and depression that affect my ability to focus and be present in my everyday life. My faith reminds me that my son's spirit lives on through our family and through everyone who loves him. While God ultimately has last judgment, society law says a person should be held accountable for their actions. I respectfully ask this court to impose the maximum sentence allowed by law. In doing this, Lake County will be sending a clear message that interfering with justice will not be tolerated, especially in cases involving murder. Justice matters. Wyllyam J. Sheffey Jr.'s life matters. Thank you for hearing me.
Thank you.
Thank you, Your Honor. Judge, you know, as the court knows, the facts of this case involve Ms. Montgomery doing essentially two things, two main things. She concealed Aviante at her various vehicle, and she concealed bullet holes and or blood that was on that vehicle in the moments following the murder of Wyllyam James Sheffey on June 7th, 2025. There's nothing about that conduct that suggests it could somehow have been motivated by her desire to protect the younger children in her family. That conduct speaks for itself. Your Honor, additionally, over the course of 1 month, over the course of the next month, she assisted her co-defendants in moving out of county, moving them out of their home at 508 Railroad Street within the hours to days following the murder of Wyllyam James Sheffey. She moved them, and it's noteworthy that she moved them out of county, the Cuyahoga County into Portage County, where they ultimately secured residence in Portage County. Your Honor, we disagree about Ms. Montgomery's intent, and we disagree about the presentation of the facts that have been given by the defense here today. With that said, what I want to focus on is a couple things. One, Ms. Montgomery was not successful in her attempts to obstruct the police investigation of this case, and that's due in large part to the Painesville Police Department. The Painesville Police Department worked around the clock to investigate the events of June 7th. They've never stopped. And because of their efforts, Your Honor, the individuals responsible for the murder of Wyllyam James Sheffey have been charged and are sitting in the Lake County Jail. I'm a little bit disappointed here today, Your Honor, to hear what's been advanced, that she did not have intent to commit a crime, that she did not do anything other than attempt to protect the children and her family. We heard a lot about how Ms. Montgomery's sole focus was her family. But what's striking to me, Your Honor, is that her family pursued, stalked, and murdered Will Sheffey on June 7th, 2025. And at no point prior to their arrest did she decide that her assisting them was somehow the wrong thing to do. For someone who places so much emphasis on family, it stands out to me that not one thought was given to Will Sheffey's family and what they were going through in those moments, not only following his murder, But in the days, and what must have felt like a very long month before any arrests were made, essentially Miss Montgomery had three choices. She had the choice to do nothing. No one's required to assist the police. She could have done nothing. She had the choice to actively assist. She could have told the police, this is what I've learned, here's where my family is, here's what we think happened. She didn't do that. Or she could have done what she chose to do, and that was continue to assist her co-defendants and her family for the month-long course of conduct that this continued for after Will's murder. She chose the wrong side of right, repeatedly. With that said, Your Honor, it's disappointing to hear, like I said, the version that was given here today. And I also want to say that the disrespect for law enforcement should not be ignored. Again, the Painesville Police Department, is because of their efforts that the individuals responsible for this crime have been charged. But in addition to the Painesville Police Department, the Lake County Sheriff's Office, State Highway Patrol, Manor Police Department, the Wickliffe Police Department, the Chardon Police Department, the Geauga County Sheriff's Office, the Cleveland Clinic Police Department, the Euclid Police Department, the Streetsboro Police Department, Westlake Police Department, the United States Marshals, the Bureau of Criminal Investigation, Secret Service, and the FBI have all participated in some way in this investigation. Those are the agencies that Ms. Montgomery attempted to thwart. And it is because of their professionalism and their diligence that she was not successful in doing so. Now, the state is cognizant, and the state has said this throughout, that Ms. Montgomery had no criminal history prior to this event. She seemingly did prioritize living a law-abiding life up until June 7th, 2025. And really, the more I learned, she seemingly prioritized living a law-abiding life until her involvement with the co-defendants, particularly the Gaines and Hatterberry family. She did indicate and showed or demonstrated that she could be a productive member of society prior to this. And I've mentioned the Painesville Police Department's investigation was not significantly impacted by Ms. Montgomery's conduct, but that is only because of their efforts. The state balanced all of those factors, Your Honor, when the state entered into the joint recommendation for community control sanctions in this case. The state feels that if the court adopts that recommendation, that only the maximum amount of jail time and the maximum number of years of supervision would be appropriate. The state also believes, Your Honor, that it's clear that Ms. Montgomery's continued rationale or explanation or justification for engaging with this conduct was for family. The state sees no way that she could be amenable to community control if she's allowed to have continued contact with those individuals. So should the court consider a community control sentence here today, Your Honor, the state believes that a no-contact order with Aviante Hatterberry, Avion Gaines, Solomon Gaston, Xavier Jackson, Lakeisha Jackson, and Roberta Gaines is required. I would just note, Your Honor, it's extremely important to note that those cases are still ongoing, and Ms. Montgomery has shown the propensity and the desire to help those individuals rather than the justice system. And that's something I would ask that the court balance here today. And when assessing, Your Honor, what conditions may be appropriate, I would simply point out that no contact, things like that, those are minimally invasive sanctions. Will Sheffey's family doesn't get to have contact with him in a year. They don't get to have contact with him in 5 years. They don't get to have contact with him at all anymore. And comparatively speaking, all of the things that we're talking about for Ms. Montgomery here today are relatively minimally invasive in her life. So I would ask that the court consider those things here today, Your Honor. The defendant does have credit for 102 days of jail time credit as of today. Thank you.
In the event that I would not go along with community control sanctions, am I allowed to oppose that order?
Not if a prison sentence is imposed.
well as the statements the defendant, defendant's counsel, prosecutor, and all those statements made here today. I consider the overall purpose of the felony sentencing pursuant to revised code 292911, which is to protect the public from future crime by this offender and others, to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanction support determined to accomplish those purposes without imposing an unnecessary burden on state or local government resources. I consider the need for incapacitation, deterrence, rehabilitation, restitution, along with that public burden of governmental resources. I consider the recommendation made by the parties to reasonably calculate the sentence to achieve the overriding purposes of felony sentencing, be commensurate with, not demeaning to, the seriousness of this offender's conduct, its impact on the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. Using my discretion to determine the most effective way to comply with the purposes and principles of felony sentencing, considered all the relevant factors, including the seriousness factors set forth in Divisions B and C of Revised Code 292912, and the recidivism factors set forth in Divisions D and E of Revised Code 292912. With respect to the seriousness factors in 292912 as set forth by the legislature, I don't find that those factors apply in this particular case. With respect to recidivism, being factors indicating offenders more likely to commit future crimes, frankly, from the pre-sentence report and investigation, even the statements meant today, and of course of conduct, I don't believe the offender does show genuine remorse. With respect to factors indicating offenders less likely to commit future crimes, the defendant has no prior juvenile adjudications, no prior criminal convictions, and frankly, has led a law-abiding life for most of her life. But the court also knows that there's no presumption for community control in this case. And while the state and defendant both asked for community control to be imposed in this case, I do not think that community control is appropriate in this case. The court's going to find that prison is consistent with the purposes and principles of felony sentencing. The defendant's non-available to available community control sanctions. The sentence of the court's defendant served a stated prison term of 36 months on count 1 and 36 months on count 2 with credit for 102 days already served. Now, the part of that I need to decide here is whether those could be served concurrently or consecutively. As a reminder, I'm also a member of the community and personally may even think that running consecutive sentences would have been appropriate. However, my job is to impose a law set forth by the General Assembly, and I cannot in good faith do that, sentence and impose a term consecutively based on what the law says. Even if I find the conduct reprehensible, in particular covering up issues with the car and hiding the car, that in the initial stages of the investigation, that could have been very important evidence for the police. Indicated by this plate, the police and law enforcement overcame the tampering with evidence as well as the obstruction of justice conducted. So again, that will be currently then for a total of 3 years with a credit for 102 days. With respect to any financial sanctions, I'm not going to impose any fine. Post-release control is part of the sentence where you may be on a period of post-release control for up to 2 years as determined by the adult parole authority. If you're placed on post-release control and violate the conditions of your post-release control, the adult parole authority may impose more restrictive post-release control sanctions to return you to prison for denial of each violation up to a maximum of half. Your violation of post-release control is a new felony, you may be prosecuted for a new felony. The court which you are being prosecuted for a new felony may impose an additional consecutive prison sentence for a post-release control violation. Maximum prison term for the post-release control violation shall be greater of 12 months, or the period of post-release control for the earlier felony minus the time you spent under post-release control for the earlier felony. That it is ordered to pay the cost of prosecution, balance the indictment would be dismissed, bond would be removed. Anything for your order, Ms. Blake?
You have 1 second.
Sure.
Nothing else with the state here.
All right. The court's very cognizant of the pain being felt by both families here, and frankly, I don't think there's anything that I can do certainly to relieve that pain, but at least I hope to some extent that there's some healing starts at some point in time here, and I do wish the defendant and as well as the victim's families.
Thank you, Your Honor.
All right.
Daryl?